again to this 50 minutes. Of course, in 50 minutes we're not going to solve all the issues, but I'm going to address it. Actually, I only need to talk about the challenges, even though I like to talk about the solutions or the directions where we should think of a bit more. But let's talk about the challenges first from the legal perspective. So the question today is for my presentation is data ownership, and can you own digital data? We're focusing on digital data, even though of course the data economy is bigger than that, but let's focus on the digital data. So to be able to answer that question, let's go back to basics. The data is a very, very short word, and if you think about data, everybody in the call, 53, and I recognize many names, good that you're here. Everybody has another thought about it. It could be personal data, it could be sensitive data, it could be encrypted data. So going back to basics is where I think we need to go to first to try to understand and to be able to address this question. So starting with definition may be a good start. And again, like I already said, data is a four-letter word, but you know what I mean. There's much more than ECI. This is a definition which comes out of the European Commission's standardization guidelines on cloud service agreements, cloud service level agreements. It may not be, and it, by the way, comes out of course, another standard, which is ISO 1. Just to show you that there are many, many different kinds of data, including indeed personal, non-personal, could be indeed proprietary data or non-proprietary data, confidential, non-confidential. Don't forget machine readable. I don't know what a judge or a court will do with that because they cannot read it. And the derived data already was mentioned is of course quite interesting and also then again a challenging topic. So it is important to first try to find out, to figure out what kind of data you're talking about before you can answer the question. So moving a bit further on, because what has changed in the world basically is that data travels. It already traveled for many decades, but now it travels all over the place, and it actually can be shared much easier. And what you see here all the way on the right is a graphic of application. So this is your application on your mobile device, but also just web applications which share data with other entities. This is just one way that data travels. The other traveling I will show you later on. So this one, just to show you a couple of words and concepts you need to talk about, you think about, is indeed data set segmentation. What kind of data are we talking about? And you know, if you think that you have classified or you have been able to put a certain type of data on a certain data set, then probably that data set also has other categories and types that it can be identified with. So data will probably have more than one, will fit in more than one category. This distribution, well, this is the example, but indeed also for other ones, what I mean is very relevant, and that's actually what has changed. We invest much more before, and now it's already, of course, for 20 years, but now if you start to think about this more, shared, and it means that people are able to do something with it, make data out of it, or enrich it, or compromise it, whatever they want with it. And of course, during that processing, a lot of derived data is generated as well. So here the example again on applications. This is another example. This is cloud computing. Just an example. We have a lot of customers talking about infrastructure as a service, and then you will quite quickly find out that they don't have one, but they have two or more, and they want to, of course, talk and communicate with each other. Not only the infrastructure, but also, of course, it's all about the data. The same goes for the platform as a service, there are probably even more, and with software as a service, well, there are not 8 in this example, there are many, many thousands which are used. And don't forget the shadow IT and the shadow cloud, shadow applications as well. At a general corporate, let's say 4,500 company, you talk about more than 10,000 different applications that are running on the shadow side. So quite a lot to do to finding out where your corporate data is, and also finding out who owns it and whether you have not ticked a box. And actually in the terms and conditions it says that the data is now owned by the vendor. So another example, and then moving it to getting it even more complex, is IoT domain, where we're also working with the Alliance Internet of Things innovation on these topics. Even more data is shared on many layers, many stacks, and this is very simplified. A graphic, of course, you can think what you see. You can think that this is a smart city with a lot of verticals and cross verticals in that big smart city vertical, and every category of data needs to be taken care of. We don't want to be holier than the Pope, but we need to take care of it in a proper way. So, can you own data? And we already had some sessions and workshops on it with Commission, but it is a topic that we need to talk about. Well, let me give you one example. Here is, well, it's not one example, but one example on how you can think about it. So these are a couple of current or upcoming directives and regulations from the European Commission. And by the way, there's also contract law, of course, that's also just on a member state basis, including international law. And also that could also be another jurisdiction outside the European Union. So if we move very quickly through these couple of, I'm not going to address them all, again, I have only a couple of minutes. Just to have can you own data? Well, let's start with the oldest one, which is the Software Directive 1991. Actually, there it was thought to put the software, taking care of software and IPR, intellectual property rights of software, in the copyright law. And it's in most countries implemented in the copyright law. That means that people now think that software actually is copyrightable. Well, to a certain extent, that is correct. Which means that you can say, well, there are certain data that people can own, but others that's actually not the case. So it really it depends on where you are looking from, where you're coming from. The database directive is 1996. Well, it is based on the assumption and actually on the requirements that you need to have done a substantial investment to build the database. Well, and the current status of the market, and we see it getting even more cheaper, it's not very expensive anymore to build a database. So which means that this directive does not really address whether or not you are owning the digital data. It has just not, I'm not saying that you cannot fix this, but the current database directive doesn't work anymore. There will be a new one, it's a trade secret directive. We don't have that yet in Europe. Of course, in the US already they have it. But the trade secret, of course, only is a trade secret as long as you keep it secret. So when data travels, you, of course, want to exchange data and share it, which means that the secrecy of your data will maybe compromised or be quite difficult to share. So on certain perspective, yes, you can own that data. And on the other perspective, if you want to share it, then you will probably lose that. Under this law. The privacy directive, the general data, I'm talking about the current privacy directive. Well, personal data is of the data subject, but then again, it is not really in their control, even though by law it is. But let me give you an example. It takes LinkedIn, I'm just mentioning a couple, I could also do Twitter or Facebook or Instagram or others, but it takes LinkedIn 11,800 words to explain how they're going to use your data. They use 138 times the word may or can, which means that for a lawyer we were lost already. Even though you are protected by law with the Privacy Directive, which is implemented per member state, the contract law in this case, ticking the box, means that you are losing control right at that moment. You're not able to say, well, I agree with this part, I don't agree with the other. So already that's why I put again a plus and a minus in front of the Privacy Directive. The General Data Protection Regulation, the GDPR, which is going to force 25th of May in 2018, have to, of course, the same topics. And again, that also goes with my example, which I just mentioned. Again, I only have a couple of minutes, so that's why I'm rushing a bit. Sorry about that. So I will, the antitrust legislation is, of course, a good one, but it only goes for really material, substantial issues. And then already the market has gone haywire. We already have a market failure, which means that, well, it works, it is an instrument to take care of, to use, but it's very difficult, and it's only in very rare occasions. Skipping the commerce directive, it's also not addressed, and perhaps it should be updated or in another way take into account this topic. Contract law, again, it's a plus and a minus. Yes, a contract law takes care of a lot of these kind of things, but then on the other side, whether it's a consumer or a institute, can be a university, but also companies and organizations, don't always have the power to negotiate or the knowledge to negotiate, and that could be say, well, that's their problem, but that means that contract law to a certain extent works, but to the other extent it does not yet. So the nice thing about contract is flexible, but it needs, of course, the effort of both parties, both the vendor and the customer, to get it to a proper maturity level. So the topics that perhaps are better to take care of and to talk about instead of ownership, perhaps the word ownership is a bit outdated, again, because it travels. You don't own the data in the sense that you own something which is in your pocket or your car. It travels, so perhaps it's better to look at data access and data use. And two main topics that pop up then is identity access management. So basically, a strong identity, who is actually able to access the data, and how can we take care of that in a controlled way. That's quite difficult, but it's possible. And then, of course, we can do that with digital rights management, a word that has been already on the market for a long time, but perhaps now with the current state of technology, we're actually able to get there. So my almost last slide actually is, okay, how do we do that? How can we take care of data access and use? Well, the approach we would take is figure out in which phase you are talking about mostly, or actually if it concerns all phases of the data lifecycle, all the way from obtaining it towards destroying it. If you are destroying it, figure out where you are and try to see then who is owning what and who has the control over it. And that's actually the word I was trying to avoid, because that's my last point. Just in time, data ownership, in my point of view, is an outdated word, and I think it's also a word that is actually confusing because it's too much focusing on owning, and it's not about owning; it's about controlling. It's about data control. And the data control basically means that you are in control of who is able to access and who is able to use it, and also that you're able to monitor it. It's not only personal data; it's also trade secret. It could also be IPR, could be sensitive data, classified data, etc. So I'm trying to get the discussion a bit more outgoing instead of looking inwards ownership. I think this would be a better term to start with. So with that, I'm just within time, and I will give it back to David.
Thank you very much. That was really